Fine.
Yes.
Perfect. Wonderful. I guess as long as we all have our cup of coffee and or tea, I'm happy to welcome everybody to our today webinar. On behalf of MCM Slovakia, I'm very glad to especially warm welcome our colleagues from a member company CMS who were glad enough to offer a very interesting and up-to-date topic for today's webinar. We will be dealing with the topic of M&A contracts in the current environment, and especially we will be trying to explore what we could learn from the last financial crisis, as we know that the current environment has been, or the current pandemic is being felt across all businesses and sectors, and basically the M&A market has changed tremendously. So the reason why we have met today is that we will be listening and also exchanging ideas, especially from the CMS Head of Corporate M&A, Miss Petra Čorba Stark. Welcome, Petra.
Hi.
To our today's webinar, and Petra will be also joined by two of her colleagues, namely Ms. Zuzana Nikodemova and Martin Balázs.
Good morning.
Morning.
Good Martin.
Hello, good morning.
And I especially like the fact that they will be shifting your attention because they have decided to all three of them would be doing this webinar directly from the beach, as you can see from their background, and they will be changing their shift in front of the screen. So pretty much looking forward to that. Before I hand over the word directly to Petra, Zuzana, and Martin, a couple of housekeeping rules from our side. As you might have noticed, this webinar is being recorded and will be made available after we wrap up today. The webinar or the recording will be available to everybody to be watched and shared on MCM webpage. So feel free to join the conversation. Feel free to step into the presentation, into slides. The chat function is available upon clicking on the conversation button, or if you feel like raising your hand and maybe stepping into the communication this way, there is upon clicking on your control panel, there is a small hand that can be clicked, and it means that you are raising your hand and waiting for the question to be posed. But also feel free to use the chat function and insert your question directly over there. I believe with no further ado, I'm handing over the floor directly to Petra and her team, and looking forward to a very interesting session on mergers and acquisitions today. Petra, the floor is yours.
Yeah, thank you very much. So let's start. I think there is a lot of expectation at the moment on the market. What will happen in the next month, and asking ourselves how to react to this. And this is in fact the leitmotif of our presentation. So just it doesn't move. I cannot move the presentation for some reason. Okay, let's think about, in fact, what can we learn from this, and if there are any new elements in this situation which are different from the previous crisis, and we can learn, of course, some new things. First of all, we would like to following various reports and charts by various companies, but we added some numbers from CMS materials. Namely, this is a material CMS prepared with Credit Suisse, and you can see some information, but the main information is that M&A volumes dropped significantly, unfortunately, in March and April. But the good thing is that from prior crisis, we can see that once the confidence returns, M&A rebounds really quickly. So let's see a chart here, which is from the same report. You can see the previous crisis, the drop of the transactions, and then in fact a strong rebound. So we can be quite optimistic. When we look at the CE situation, on the right side there is a chart. Again, you can see there is a decrease of volumes of the deals and also counts of the deals. So also in CE we can see a significant drop. But on the other hand, we can be, I think, cautiously optimistic, because if we look on Central and Eastern Europe on the left, we can see that investors still think that CE is attractive. Of course, this can change, but this is maybe the sentiment at the moment on the market. Sorry. In the last 3 months, I think deal makers were really uncertain how to continue with their deals, and if their deals should be like continued, stopped, suspended, and for like certain provisions which were used in transactions so far became, I would say, questionable or needed to be analyzed now in this new situation. So if the deal has been still just negotiated and has not been, it was necessary to analyze the risk of termination, if there are some break fees, and if there is any risk of potential, let's say, damages for terminating a transaction due to the COVID situation. If the deal was signed but has not been completed yet, the material adverse change clause, and checking if it really covers the situation, the COVID situation, or standardly enables the buyer to terminate the deal which has been signed but not closed yet, in particular in the situation when the target's financial situation had worsened significantly. But a lot of times the MAC clause has an exclusion for situations which affect the market in general or certain sector. So maybe in the future we need to think about it, because this COVID-19 situation was in fact a general situation. So it can be difficult to defend the MAC clause and terminate the contract in this instance. Then if the deal has been signed and closed already, the question is if it can be terminated, let's say for force majeure or on the basis of different legal instruments, but this is very not standard to terminate a deal once it has been closed. So this is quite problematic, but of course this is something to be considered maybe for the future. We checked internally with our colleagues if they have done any deals during the COVID pandemic in CE, and they have done. It was like different kind of sectors. There was no real estate, but it was energy sector or lease sector or some other sectors. And it was interesting to find out that half of the deals was done remotely, completely negotiated remotely, and also signed remotely. Of course, I'm sure, and Zuzana will mention later, it's not so easy to do all the signing remotely. There were some technical problems, but yeah, we can come back to this later. Next slide. And now we would like to look at the CMS European M&A study. We will compare a study from 2010 and from 2020. This study has been prepared by CMS for already 12 years. So it's a really great basis for comparing check if the market how the market was, if it was buyer friendly or seller friendly. And the same CMS study is in fact following systematically the deals made by CMS in Europe and make some statistics in relation to some clauses, typical share purchase agreement clauses. We picked 3 clauses, and we are comparing the results of the 2010, so which refers in fact to 2009, so in fact post-crisis or crisis SPA, and we are referring to 2009, a year prior to our current situation. So the first where we were checking is the purchase price adjustment clause. This is a mechanism where the purchase price for the shares is final only upon completion. So there are financial accounts done after the completion, as of the completion date. This is different from the law mechanism when the price is fixed at signing. And the results we found from the previous crisis were slightly like counterintuitive, because it's apparent that there was less purchase price adjustment as a result of the previous crisis. And if you read any like materials or advice at the moment, you will find that the buyer should be like requesting, in fact, purchase price adjustment. But the reason probably is that in fact there was a distress, and because of this distress the sellers were selling like at the lower price, and simply because the price was low, the buyers were able to buy like at the fixed price. What was interesting in the study from 2010, we found that the CE trend was different. We don't know why, in fact, but probably or possibly it was the fact maybe the CE was hit by the crisis, the financial crisis at the later stage. So maybe this is the reason, but we don't know 100%. Here you can see a trend of the use of the purchase price adjustment from 2010 to 2019, and it's clear it's like increasing. So of course now it might change, but let's see. Yes, what happens. Another element is liability caps. It's like a maximum liability of the seller for the warranties or breach of the warranties. And it's interesting because the liability cap, like higher liability cap, which are more than 50% of the purchase price, has increased, or their usage has increased in 2019. And this is probably because the market was simply buyer friendly and buyers were able to push higher limits for the sellers. So the sellers had to accept higher limits. Here we are showing the opposite. It was like a purchase price which was below 50%. So before we said above, and this is below. And you can see also the popularity at 2010 was less, and it was like the popularity increased with time. So the trend in 2019 was an increase of the popularity of the lower caps, which indicates, of course, that let's say in 2019, also 2007, the sellers market, the sellers were quite in their position to negotiate transaction. And the last element we were checking is the limitation period. So for how long is the seller liable for the breach of the warranties? And in the previous crisis, it became clear that there was an increase of the shorter limitation periods, because simply it didn't make sense to have longer periods because of the seller could be bankrupt, or the seller simply wouldn't have proceeds to cover the limitation, the warranties. So this was the reason there were more, I think, more limitations on time. And Yes, I forgot to show that we have some graphics here. And this is just maybe you can see here some longer limitation periods, and we focused on real estate. You can, because this is a typical target in Slovak Republic, and you could see that if we took an average from 2010 to 2018, the long limitation periods were in 29% of the deals, but in 2019 it was only 16% of the deals. So the limitation periods got shorter, but the long limitation periods were not applied so much. But probably this was caused by the fact the sellers had a very strong position. And now to Zuzka. She will speak about some financial documents and the implication of COVID.
Thank you very much, Petra. When we speak about M&A transactions, they typically come hand in hand with some financing, because M&A transactions are very often financed from some external sources. So in respect to the pandemic situation, we were also dealing with the issues how quarantine or some business interruption measures would affect the financial covenants, financial obligations. I would highlight only a few issues we were discussing in the contractual documentation, as well as some post-closing obligations. First of them was force majeure, whether this would apply to the given situation under the closure and distressed situation. It has to be mentioned that force majeure clauses are very unusual in financial documentation, in loan agreements, or in underlying security documents, as typically the lender performs his obligation to provide funds already in the beginning, and wouldn't typically agree with some delay or cancellation of borrower's obligations to pay interest or repay the loan due to the force majeure situation. Therefore, in respect to such matters, they are more subject to individual agreement in form of a waiver or some amendment to the loan agreement. But I also have to mention that during the pandemic situation in Slovakia, we agreed once to a force majeure clause in a security document when the central depository in Slovakia was closed completely for 2 weeks, and it was difficult to predict how the situation would develop. It was later opened for registration in form of postal filings. However, in case of registering the pledge over the share certificates, it's necessary to make this registration in person. So again, this solution wasn't possible under such situation, and therefore we agreed to the force majeure clause in the security document to cover this untypical but difficult to solve situation when the registration for some time wasn't possible. Another clause which we have dealt in the finance documents was material adverse effect clauses, where certain events would trigger event of default. It has to be mentioned that there is no case law, or I am not aware of any case law in this respect in Slovakia, and also in case of loan agreements governed by, for example, English law, there is not much case law which would give us some comfort to say how the courts would decide at the very end in favor of which party. And therefore, we always recommend it to reach some agreement between the borrower and the lender and solve the situation by an agreement. This could also be the reason why in most countries loan moratoriums were adopted, to provide some comfort to all parties, especially to the borrower, to deal with the difficult situation caused by the pandemic. When we come to the post-closing obligations, typically under the finance documents, a borrower has to fulfill certain conditions precedent prior to utilization. One of them is the corporate approvals. The pandemic showed that this has to be considered in time, and also technically how this could be solved, because not all entities have in constitutional documents a possibility for some parallel approval. Until the state approved this parallel possibility also for entities which didn't have this in the constitutional documents, it was difficult to perform such a corporate approval very quickly. So this lesson has learned us to consider and check whether these corporate approvals in the given situation would be possible also parallel or not, and apply them ahead. Second topic which has made us busy during the pandemic are the registrations. As mentioned, the central depository was closed for some time, so we had to agree with some prolonged deadlines and deal with the situation that the register was closed. It wasn't a situation only in Slovakia, but I have to mention that we were dealing a bit also with the UK law, and during the lockdown, it was also not possible to, for example, obtain apostille for the documents. So again, this was an obstacle which we could not overcome for some time. And during the pandemic, it's always difficult to predict how long such situation would last. And it's better to think of it ahead and incorporate it in the documentation. Now I would move the floor again to Petra.
Yes. Okay. We will speak now a little bit about the distressed M&A. I would say yes, the COVID situation was what we experienced in the last 3 months, and what will happen now, we are not 100% sure, of course, but we would like to be prepared, and everybody would like to be prepared. So we also looked at past deals, and what became clear is that if there is a distress situation, of course, there is the risk that the target will get worse. I mean, the financial situation of the target will get worse, and this creates, in fact, time pressure. So everything needs to be done really quickly. But on the other hand, there are multiple parties who are affected, mainly the creditors of the target. So it might be quite like stressful to coordinate in so many parties in such a short time. And of course, also because of this, there is no time for exclusivity and discussions, if it doesn't work out, to go to another interested party. And this is the reason that many times there is no exclusivity. It is just simple, like simultaneous negotiations, and the sellers are really trying to sign and close everything really quickly. Distressed M&A has also some structuring specifics of the transaction, and like many times, and if Aon is on the call, I'm not sure if they're here. I would like to ask them to jump in if they're on, or some other, insurance company. But in general, it is possible that the sellers will not be able to meet their warranty or indemnity claims. because of the seller can be insolvent or have no other assets. And for that reason, sometimes or many times the targets are simply sold as they are and where are. So it means, and also because the situation of the target, yes, so it is acknowledged that the situation, it's a distressed asset. So also for this reason, maybe there is doesn't make sense to give long standard warranties of few pages, and only really like limited representations are provided. But sometimes the buyer will need some security of the liabilities of the seller, and there is a risk the seller will not be able to meet this liability, so the escrow is required by the buyer, and this can be substituted by insurance. I understand that there are some insurance products also at the moment on the market who would be applicable in the distress situation. So I'm not, probably Aon is not here, doesn't matter. But
Aon is here,
I know
thank you.
Yes, okay, great.
Of course.
So can you comment on this?
Maybe just very shortly, because you are better professional, but when you are mentioning insurance products, I can mention warranties and indemnities, or representations and warranties, or title insurance, or some
Mr.
other
Cipri,
similar
excuse me.
products. Yes, please.
Excuse me, there is a very strong echo in your microphone.
Okay, I'm using headphones, and so sorry for this. So therefore, I will not speak very long time.
Definitely better right now.
Okay, thank you.
Much better.
So I was just mentioning that, of course, there are insurance products who are like good alternative to, I would say, historical, more used escrows. And I would mention warranties and indemnities, or title insurance. And this is, I think, especially in this time, and about the different interests of both parties, good compromise which could keep the comfort on buyer side, and on the other hand keep or let seller actually with clean exit, I would say, very shortly. Thank you for the opportunity to mention these products.
I think it's like very useful, because I think it gives more flexibility to the parties. So
exactly.
And another clause we wanted to mention, it's an interesting clause, it's called anti-embarrassment provision. And it is connected to the fact that sometimes, in fact, as we mentioned, the situation is very stressful and there is no time. And for reason there is no marketing of the target sale. And it can happen that the price the buyer is paying is not optimal. And there is a risk that the buyer will resell in short time the target. So this provision, in fact, covers that risk and entitles the seller to some additional payment or premium in case the buyer sells the target in short time after the acquisition. In relation to the M&A structuring, quite often, I think most of the time, there is some carve out of the assets which are going to be sold. So yes, I would say some maybe cherry picking. We can speak about it like a risk of that next. And so the assets are transferred to a new entity, and then the new entity is sold. And this, of course, yes, it's a, I would say, intra-group transaction, which must meet some criteria, in particular because everything is done in the context or in anticipation of the insolvency process. So there are some risks connected to that. So to highlight some risks of the distress M&A, first of all, due diligence is done in very short time, and it is very difficult to rely on the seller's information because they might simply hold back some information. And yeah, but this is the risk of the situation. But it is necessary to collect as much as possible public information. Of course, not everything can be identified from public information, but yeah, so we need to try that. Especially in relation to transfer of assets, I mean, if there is no share deal but asset deal, and there is a cherry picking, or in context of these carve-outs, it is in mind that some liabilities are transferred anyway, even if we are doing the cherry picking. So, for example, employment liabilities may pass. I'm not saying in all situations, but this needs to be checked. And also, let's say, environmental liabilities. And I remember I experienced after the previous crisis situation, the client was exactly like cherry picking some plant, like parts of the plant. And the issue was, in fact, the environmental liabilities. Like, we solved this, they accepted certain risks, like following from environmental burdens, but in fact, they were not able to exclude that risk completely. Then we will speak about this in more details, but of course, because of this transaction happening quickly, and there is not enough maybe marketing, no time for marketing. There are risks, the buyers pushing the price below, like lower. There are potential challenges to the undervalue of the transfer, but this is connected. We will speak, in fact, in relation connected to the position of the creditors or insolvency situation. Of course, in communication with the creditors in this kind of transactions is very important, and it is also necessary to take into account that if the seller is selling the target, and if it becomes insolvent and the transaction, it can happen that the management of the seller will lose control, understand who is the seller, not only who is the target, because then the creditors can take control, or the administrator, yes, and the deal will have a different direction. The last point in this slide I want to mention is the management. Especially if there are these asset deals, there are risks for the management. So it's very important for them to be covered. So this is connected with the transfer of assets. It is important for the management, but it's also to cover the whole transaction, to have some valuations, third-party valuations, just maybe not completely eliminate, but minimize the risk of challenges. Challenges not only for the transaction, but the personal liability of the directors. But we will mention this also in more details. And now I'm handing over to my colleague Martin, who will speak about the risk of challenges to the transaction.
Thank you, Petra. So when speaking the market with distressed assets and selling a distressed asset, we have to keep in mind that there is the risk that the company will go bankrupt, or is already the time of selling the asset insolvent. So the creditors may later not be satisfied, and there is a high risk that they will take an action against the company and try to get the value back, or to benefit from the transaction which has been made. These so-called clawback actions are really risk which has to be kept in mind. And so what is really important to see in these transactions is the critical period in which the creditors can claw back these actions. We are in particular speaking about three types of transactions. You can see them there on the slide, the undervalued transactions, and then we have transactions which prefer or curtail certain creditors. As we already expect some bankruptcy or insolvency of the target or the company, we will now speak about the critical periods which relate directly to the bankruptcy. In general, the period for the creditor to challenge these actions is 1 year before the commencement of the bankruptcy, or 3 years if the transaction was made between related parties. And in case of curtailing transactions, the critical time period is 5 years before the commencement of the bankruptcy of the target.
I can say that within the pandemic, there was a saying that the cash is the king. In respect to the voidability, I would say that in case of transaction in some distress situation, it's really necessary to record and make be sure that there is justification why the transactions are made under given circumstances, under given value, and have this recorded as best as possible, so that later when there will be discussions or a possibility to challenge such transactions, this could be justified to the best level as possible, because it's difficult to foresee what will happen in the future. So it's our recommendation to consider this point when making the transactions in such situation.
Yeah, exactly. So keep in mind, even if selling some certain assets carved out from the company, there is still the risk that some creditors will take an action against the company and try to get a benefit back in the critical period. So moving to another risk, or director's risk in general, the directors have to monitor the status of the company on an ongoing basis. And if they realize that the company is insolvent or is over-indebted, they are obliged to file a petition for bankruptcy within 30 days from the moment they realize that the company is insolvent. Failing to do so, there are pretty severe sanctions for breach of this obligation. The directors will be obliged to pay a penalty amounting currently to 12,500 euros. Plus, they can be held liable for the loss cost to the creditors of the bankrupt company. Ultimately, they can be even held criminal liable for the fraudulent bankruptcy. So the whole situation is pretty severe, and the directors have to really keep in mind that there are some obligations connected to the whole company. As we have already mentioned, there are some actions which can be really clawed back, and in general, if the director of the company causes loss to the creditor, he can be held liable even if the company doesn't go bankrupt. We have, I would say, we have found only a few cases, but the trend is really now that the creditors try to get the value of the transactions back. So not only the trustees, but also the creditors are really now filing petitions or actions against the management of the companies. The first case which we see here is decision of the regional court in Bratislava, where the directors were held liable for late petition for bankruptcy. Basically, the company has been was over-indebted for several years, so it was clear that the directors knew about the situation of the company because of filing the financial statements of the company. So the court held it pretty clear that they were liable for not filing the petition for bankruptcy, and the directors were then liable for the whole loss which was caused to the creditor of the company, which was much higher than the penalty. And this is a decision of the Supreme Court. The director was held liable for the whole loss caused to the company because he terminated an agreement prematurely and the company did not meet the expected remuneration which was agreed in the agreement. So basically, in general, breach of the duty now pretty clearly leads to the obligation to remunerate the loss which is caused to directors. So we are now approaching the end of our presentation.
No, just a
I would just say a few words in respect to what Martin said, what came to my mind, to again stress that the paper is the queen. It's not absolutely impossible to avoid liability. You have enough evidence. There are already a few court decisions which recognize also informal restructuring as some attempts of the director to act with due care to avoid bankruptcy and to act
Zuzana, excuse me. Seems like we have lost the connection.
Okay, už to pôjde.
Zuzana, there you go. Seems like you are back.
Sorry. Yeah, we had technical problems with apologies. So there are already some case law recognizing also informal restructuring. So the talks with creditors on restructuring, some financing and so on, which could relieve the director of the obligation to not to file in time for the bankruptcy. Another point I would mention at the end is that since 12th of May, we have the possibility of the bankruptcy moratorium for businesses in difficulties. This has some pros and cons from all sides of the business environment. For the entrepreneur and such protection, it gives him some time to breathe, to stabilize his business, to renegotiate and to find some solution for his business in difficulties. However, it brings also some negative sides. For example, in case the entrepreneur is under such temporary protection, it would be difficult to make any transactions with his assets because law says that he should not make any transactions which would materially affect his business or change his business. So in such cases, some cherry picking and assets deal would likely be very difficult. The share deals would be more common. However, these provisions are very new and it's difficult to predict how the courts would decide if entrepreneurs and in such situation, it's highly recommended to analyze the risk that such transaction in case of the asset deal would be affected and later challenged. So these are my final words from the act of insolvency, and thank you very much for your attention.
Yes, so if you have any questions, please do not hesitate to ask now, or you can send. I need to check my chat if we have any questions.
So far, there are no questions in chat.
Okay.
But I definitely would like to encourage our participants to feel free to unmute yourself, turn on your cameras perhaps, and feel free to pose your question directly or ask your question directly. We have a couple of colleagues from law companies, from tax companies, some accountants. We have insurance companies connected. So I believe this is a nice time. Next 10 minutes that we might dedicate to Q&A session.
And also, if you don't feel like you asking now, no problem. You can also send me an email or send us an email, and we can reply by email, or we can go for a coffee. It's possible already. So yes.
Perfect. And there is also a nice function when raising your hand. It looks like this. If I click on it, then people might see a small yellow hand next to my name. So feel free to use this function as well. Do we have any questions from the floor?
Probably no.
No questions so far. Mr. Ziprich, maybe any more comments from your side? You were the one entering into the discussion with your comments.
Actually, I was pushed to enter, but thank you for this opportunity. I was not preparing myself. I was more expecting passive participation, but once you are mentioning, I think that my recent learning is that there were like 2 deals which I was somehow involved from this M&A world, and the result was that due to this, because they started before COVID-19 crisis, and the expected closing date, it should be in, let's say, April, and both deals were postponed from the buyer's decision, because further the COVID-19 crisis was coming, and including also Slovakia and all these, let's say, commercial impacts. This was really difficult for, let's say, of course, sellers were pushing to close the deal as soon as possible, to follow the originally discussed and somehow pre-agreed conditions. But buyers, they started to be a bit, let's say, more considering all the things, even if they were already like mutually pre-agreed. And at the end, they decided that no, guys, we will wait, and the deals are still on the table, but they are postponed. So everybody is waiting for, let's say, maybe autumn after the summer holiday, and maybe clear view on how this COVID-19 will go further, whether there will be the wave 2 or not. And so this is like a quick update from my side on this.
Interesting. Yes, I think everybody is like more cautious now, and not only in relation to COVID, but like in general. Yes, because there is uncertainty what will come. So nobody is probably in a hurry to close anything at the moment.
But thank you for your comment, Mr. Ziprich. Highly appreciated. Do we have any other maybe comments, inquiries, some more questions to our speakers, to all three, Petra, Zuzana, or Martin?
Okay, I think.
Even no, then I guess I also see a couple of people also leaving due to other arrangements starting at 11 a.m. If there are no further questions, thank you very much, Petra, Zuzana, Martin, for your effort, for your dedication. On behalf of MCHEM, thank you very much for your time. We highly appreciate your slides, your wisdom, and as was promised at the beginning, we will share the recording with our members on the webpage. That will be made available to everybody who is interested in the topic of mergers and acquisitions.
Thank you.
Thank you very much.
Thank you all, and have a good day.
Bye-bye.
Thank you.
Yes.
Bye-bye.
Bye.
Goodbye.